Good afternoon, and thank you for joining us for a Tax Practitioners Board webinar. My name's Julie Shaw, and I'll be hosting today's session. I'd like to begin by acknowledging the traditional owners of the land on which we meet today. In the spirit of reconciliation, the Tax Practitioners Board acknowledges the traditional custodians of country throughout Australia and their connections to land, sea, and community. We pay our respects to their elders past, present, and future. We extend that respect to all Aboriginal and Torres Strait Islander peoples today. Now, today's webinar has been created to connect directly with you, the tax practitioner community. We value your opinion, and today's an opportunity to raise any questions you have directly with us. Following the webinar today, we'll provide a copy of today's presentation slides, and we'll send these to you via the email address that you used to register for today's session. You can also access the slides now by visiting the Webinar Resources Hub, and that's located on our website at tpb.gov.au/webinar-resources-hub. I'd also like to remind you that today's webinar will count towards your continuing professional education, and you can claim 1 hour for attending. I will just mention here that we do not issue attendance certificates today, but we will email you with a notification to say that you've attended, and you can use that as proof of attending today's session. So let's have a look at what we'll be covering today. Today's presentation focuses on your responsibilities under the Code of Professional Conduct, which we'll refer to as the Code today, to protect client information and effectively manage conflicts of interest. Specifically, we'll look at an overview of the Code, Code Item 6, which covers confidentiality of client information, Code Item 5, which covers conflicts of interest, the potential consequences for failing to comply with the Code, and we'll also look at some real-life case studies. Then to finish up, we'll answer some of the common questions that we received during the webinar today. So in that regard, we have Nadia Harris joining us today, and she's the Director of Policy and Legislation at the TPB, and she will respond to your questions as we go. So please make sure that you enter those into the chat box. So just before we do begin, I'll introduce our speaker for today. We have TPB board member Deborah Anderson presenting. Welcome today, Deborah, and thanks for being on board. I'll hand over to you so that you can kick off the presentation.
Thank you for having me, Julie. It's such a pleasure to be here, and it's so nice to see so many familiar names in the attendees list. It's hard to believe it's already mid-February and we're all, feels like we've been back for ages. Today, as Julie touched on, our main focus is to help you understand your obligations under the Code of Professional Conduct, and in particular your obligations around confidentiality of client information and managing conflicts of interest. To begin with, I'll just take a really high-level look at the Code just to give you a bit of a refresh. From the moment you are registered with the TPB, you are required to comply with the obligations under the Code of Professional Conduct, which is set out in the Tax Agent Services Act 2009, or the TASA for short. The Code has 14 items and it's grouped under 5 key principles. The first principle, which I don't think is an accident that it was number 1, is honesty and integrity. And under this principle, you must comply with the taxation laws in the conduct of your personal affairs, and you must also receive money or other property from or on behalf of the client that you hold the money or property on trust. You need to account to your client for that. The second principle is the independence principle. And with this one, you must act lawfully in the best interests of your client, and you must also have adequate arrangements for the management of conflicts of interest, and that's what we're going to be looking at today. The third one, the confidentiality principle. And that principle outlines that you must not disclose any information relating to a client's affairs to a third party without your client's permission unless there is a legal duty to do so. And I'll be focusing on that one today as well. Next is the competence principle. And here it says you must provide a competent service, you must take reasonable care in ascertaining a client's state of affairs, and you must ensure that the taxation services are applied correctly, or the taxation laws, I should say, are applied correctly. Under the Code, it also has a series of what we call other responsibilities. And in that, it outlines that you must not knowingly obstruct the proper administration of taxation laws. You must advise your client of their rights and obligations under the taxation laws that are related to the practitioner services that you are providing. You must maintain professional indemnity insurance that meets the specifications of the TPB, and you must respond to requests and directions from the board in a timely, responsible and reasonable manner. And I have to say, one of the things that constantly amazes me, because I sit on the conduct committee, is the amount of people that never respond to the TPB when we send them a notice of investigation. That might be a webinar for another time. So now that I've looked at the code at a really high level, I want to turn your attention to code item 6, which is confidentiality, and how it applies to the way you carry out your role as a tax practitioner. Now, when I use the terminology tax practitioner, I'm talking about whether you are a tax agent or a BAS agent. It's the encompassing term, so tax practitioner. I'm not ignoring BAS agents. With changing business practices and advances in technology, confidentiality has become an even more important issue. Under Code Item 6, you must not disclose any information relating to a client's affairs to a third party unless you have obtained the client's permission or there is a legal duty to do so. And I'll break that down and look at that requirement in a little bit more detail now. Information refers to the acquiring or deriving of knowledge, and it includes, but isn't limited to, capturing information known about a client. It could be acquired directly or indirectly from the client or from other sources. It's only necessary that the information relates to the affairs of the client. It doesn't have to belong to the client, or it doesn't need to have been directly provided to you by the client. So as you can see, it's quite broad. So who is a third party? For the purposes of Code Item 6 and the TASA, a third party means any entity other than the client or you, the registered practitioner. So this includes people that are related to the client or yourself, the practitioner. It could be their husband, their wife, your husband, your wife, your dog. Entities that are that you've engaged to do outsourcing work. So that could be another tax practitioner, it could be a legal practitioner, or it could be a contractor within your business. Anybody within the same service trust structure, unless the client is defined. So, for example, if in your engagement letter, if you have said, you know, we are looking after Joe Bloggs and his whole structure, related structure, it's encompassing. Otherwise, it's Joe Bloggs. And it also includes maintaining off-site data storage systems, and many of us know that to be cloud storage. But it could be, you know, that you've got boxes of archive boxes in Kennard storage down the road. I'd like to move on now to look at when you can disclose client information. So before disclosing any information relating to your client's affairs to a third party, you should clearly inform your client about the information that you are disclosing. You need to advise your client to whom and where the disclosure will be made, and get your client's written permission. This permission can be via a signed letter of engagement, it could be a signed consent form, or some other sort of communication with your client, such as an email. While it's not compulsory, we do highly recommend that you use an engagement letter. An engagement letter is the starting point in all your ongoing communication between yourself and your client, and it provides a common understanding between you both, clarifying the roles and responsibilities of the practitioner and also of your client. It's really useful in that it can also assist in avoiding disputes over fees and also scope of work, which is really important in our, fixed fee type environment. Engagement letters can also provide an opportunity to advise clients of your arrangements to disclose information to third parties as part of your usual business practices. And Julie will send you out some further information about engagement letters after today's session. But we do have a number of webinars that we have covered it in the past, and have a look at our YouTube channel for those. So you can only disclose information relating to your client's affairs to a third party without your client's permission if you have a legal duty to do so. So an example of what a legal duty to do so looks like, it could be providing information to the TPB under a notice issued under the Tax Agent Services Act. It could be a court or tribunal pursuant to a direction, order or other court process. Could be AUSTRAC in accordance with reporting obligations under the Anti-Money Laundering and Counter-Terrorism Financing Act 2006. Or it could be the Australian Tax Office concerning taxation laws, subject to that material being properly withheld under legal professional privilege, which I'm not going to go into here today. Just as a note, if you are concerned whether there is a legal duty to disclose client information to a third party, you really should consider seeking independent legal advice. Now, to keep it a little bit interactive, we're going to do a quick poll. Julie's going to do the first one, and it's a bit of a scenario. Are you ready, Julie?
I sure am. I'm ready to go. So we're going to put this poll live now. It's just a very quick one, and it's just to reinforce some of the information that we've been learning about from Deborah so far. So the poll should pop up on your screen in just a moment, and then we're just going to ask you to select the correct response from the multiple choice list. So the scenario that we've got for you here is Olivia is a registered BAS agent. She is contacted by the International Bank, a financial institution, requesting certain financial information relating to Darcy, who is one of her clients. The International Bank explains that the information is required to support Darcy's finance application for a new car. Now, before disclosing any of Darcy's information to the bank, Olivia requests Darcy's permission to provide the information to the bank via an email. So in this situation, do you think Olivia has complied with her obligations under Code Item 6? So we have 3 options for you to choose from here, and the ones that we've got are yes, no, or unsure. So I'll just give you some time to select the response from the list, and then we'll come back and we'll share the results with you in a moment. Okay, thanks to people for putting through responses there. We're still waiting on a few more to come through, so I will keep the poll open for a bit longer. Okay, just a few seconds more. And we might close that off now. So we will share the results. They should come up on your screen again as well in just a second. But what we have looking so far, we've got about 80%, 79% saying yes, about 12.5% saying no, and about 8% saying that they're unsure. So thank you everyone for putting through your responses. Deborah, I'll hand back to you so that you can discuss the results with everyone. Thank you.
Sure. And I'm glad you said 79%, because one thing that tax and BAS agents have learned over the last 2 years is 79 is not 80. When we've looked, anyway. In this situation, Olivia has complied with her obligations under Code Item 6 because she did ask permission from her client, even though it was via email. That is acceptable. So she did get consent from her client first. So an email is fine, for unexpected requests of client information. It's, the standard sort of communication. So now let's have a look at inadvertent disclosure. Let me I've just got to change my screen again. I forgot to go back to the slides, sorry. So inadvertent disclosure. So let's explore what you need to be aware of in relation to inadvertent disclosure of client information. So firstly, you must ensure that you have appropriate arrangements in place to prevent inadvertent disclosure of client information through recklessness. So inadvertent disclosure of client information could occur through the use of public computers. So ensuring there are appropriate controls to prevent third parties from viewing client information. Things like recycling office paper, which includes personal details concerning clients. Think about that at home if your kids are using the back of tax returns to do pictures and then hang them up, things like that. Leaving client information in unsecured locations which may be accessed by third parties. Disposing or trading in or selling your used IT equipment that contains or stores data that can be accessible by third parties, and it's a big one, isn't it? So, be particularly careful if you're upgrading your computers or multifunction printers, and remember to protect the security and confidentiality of your client records by making sure you completely delete any data contained on the hard drive of any equipment that you are discarding or reselling. I give my son a hammer and tell him just to go for it. The use of shredding and data disposal services, making sure that they are secure. The use of external service providers, which include IT consultants and cleaners, it doesn't matter what or who they are, they can be a third party, and we do need to be really aware of it. So it's not just the code that you need to consider when it comes to confidentiality of client information. You also need to consider the privacy principles under the Privacy Act 1988, which I'll have a brief look at now. So the Privacy Act 1988 sets out a number of privacy principles which govern the use of storage and disclosure of personal information and other conduct by organisations. Some of these privacy principles may have a direct impact on the requirement to obtain consent, whether that be express or implied from your clients, and you should seek your own advice about whether the provisions of the Privacy Act apply to you. Information about obligations under the Privacy Act is provided by the Office of Australian Information Commissioner, or the OAIC, always gets me. I'll get Julie to send you a link to some of the relevant information after this webinar. So let's have a look at some examples about how confidentiality of client information might affect tax practitioners on a more practical or day-to-day basis. So the first one is we're looking at cloud computing. As you know, most tax and BAS agents are increasingly using the cloud for a range of purposes, such as information storage, lodgement of returns, digital signatures, client information portals, and also just practice management software. As a registered practitioner, you must understand the nature of any cloud arrangements that you enter into, particularly how these arrangements impact the storage of your client's information. In the TPB's view, tax practitioners need to consider a range of factors when you enter into these kind of cloud arrangements. Here's an example to illustrate how we see the application of the code in the cloud environment. In this case, we've got Stephanie, who's a registered BAS agent, and she's engaged to prepare the business activity statements for a small business. Stephanie uses cloud computing software to store all her client information, data, and all the files are located on services located in Australia, but they are operated by a third-party foreign company. Prior to using the cloud software to store client information, data, and files, Stephanie obtains signed written consent from her client, authorising her to make the appropriate disclosures to the third-party foreign company. So in particular, in this case, Stephanie arranges for her clients to sign a letter of engagement, which sets out, amongst other things, precisely what entities will have access to client information, data and files as part of her cloud computing arrangements. So in this situation, Stephanie has complied with her obligations under the code, item number 6. Importantly, this example highlights some of the key obligations for tax practitioners that are: prior to disclosure of any information relating to a client's affairs to a third party, you need to clearly inform your client about any information that you are disclosing, and including to whom and where the disclosure will be made and where the data will be stored, and obtain the client's permission. You must also obtain permission from each client prior to divulging information to a third party. And as we've discussed, client permission may be granted by the use of a signed letter of engagement. It's important to note that in this situation, in order to disclose appropriately and for the client to be informed, you must first understand the cloud computing arrangements for the software you are using and the implications that these have on how information is accessed and stored. So we have put together a practice note on cloud computing. It's very comprehensive. I highly recommend you read it. Julie will send a copy of it at the end, or a link to it, at the end of the presentation. And that looks at factors to consider when entering into cloud computing arrangements, and also the consequences of having inadequate cloud arrangements. These practice notes are living documents, which is why we send you a link. And so if you haven't had a look at our practice notes for a while, go back and have a look, because we do revise them to keep them contemporary, and they're very, very useful. So here we're going to go on to another example, and here we'll look at outsourcing. So Jackie, who runs a local coffee shop, she has engaged Tony's Tax Services, Tony's a registered tax agent, to prepare and lodge her outstanding BASs, and also to provide tax advice regarding the proposed sale of her coffee shop. Tony engages Bella, who is a registered BAS agent, to prepare the outstanding BASs. In order to send Jackie's information to Bella to enable Bella to prepare the outstanding BASs, Tony's Tax Services needs to disclose its arrangement with Bella in its letter of engagement with Jackie. Now, in this case, he is using a letter of engagement, but if he doesn't use a letter of engagement, he still needs to disclose it. So Tony's Tax Services obtains Jackie's explicit permission by way of signing that engagement letter to disclose that information to Bella. So Tony has complied. If he does get Jackie's permission, he has complied with his obligations under Code Item 6 in this situation. So Julie, you're going to do another poll for us.
That is correct, yes. So again, we're just going to ask you to consider the following scenario and select the correct answer from the multiple choice list. So I'm going to read out the scenario first, and then we will launch the poll for everyone. And I just ask people not to put through their responses in the chat. It just blocks up the chat so we can't get to all the questions. So please refrain from doing that if you can't access the poll. So let me just go through the scenario for you now. We've got VCO, which is a large accounting firm and registered tax agent company. To minimise its operating costs, VCO enters into an offshore agreement with a data processing firm in Vietnam. Now, the processing firm will perform all the data processing work for VCO's clients. So in order to send the client's information overseas for processing, what must VCO do? Should they disclose its arrangement with the overseas firm to all clients, obtain clients' permission, complete a signed agreement with each client, or all of the above? So let's go ahead and launch that poll now, and we'll give you some time to put through your responses there. And then once again, we will come back and share the results, and Deborah will let you know what the correct response is.
Is the poll open?
Yes,
Julie?
I can see putting it through some responses there.
There it is. It's all of a sudden come up for me. Thank you.
Yeah, sometimes it does take a second or two to process. So we are getting some responses coming through, and I will keep it open a little bit longer so that people can put through a response if they wish. I think we've got about 43% of people responded so far. So if you do want to put through your response, go ahead and do that now, because we'll shut it off in a second. Okay, thanks to everyone that has put through a response. We will close it off now. And like I said, we will share the results on the screen. So what we've got so far is about 2% saying that they should disclose the arrangement with the overseas firm to all the clients. About 5% are saying they need to obtain the permission of the client. Another 5% say complete a signed agreement with each client. And about 87.5% have said all of the above. So Deborah, I'll hand back to you and you can explain what the correct response is for that one.
Okay. So in this situation, to comply with the obligations, VCO should absolutely disclose the offshore arrangements with all their clients. They need to obtain their clients' explicit permission to disclose the information and complete a signed agreement with each client. So answer option 4, all of the above, was the right answer in this case. So it's really, important to remember that VCO will have primary responsibility for the provision of the relevant tax agent services, including the data processing work, which is being undertaken by the offshore company. So it does still relate, the responsibility is still theirs. So the next code item we're going to look at today is code item 5, managing conflicts of interest. Now, registered practitioners must have adequate arrangements in place to manage conflicts of interest that may arise as part of the activities that you're registered to provide. Code item 5 does not prohibit you from having conflicts of interest. But it rather creates an obligation to appropriately manage the conflicts that arise or that may arise in your business. So let's determine exactly what we mean when we are referring to a conflict of interest. So a conflict of interest arises where a practitioner has a personal interest or a duty to another person which is in conflict with the duty owed to a client. So a conflict of interest can arise before you accept an engagement or at any time during the engagement. A conflict of interest can be actual or a potential conflict or a perceived conflict. So an actual conflict of interest arises if you have multiple interests and cannot objectively and impartially act in one of the interests. And a potential conflict of interest arises where you have multiple interests and one interest could possibly impact the motivation to act for another interest. And I mentioned there the perceived, conflict of interest, because if, for example, you're dealing with, husband and wife, how do you decide between them? And I'll go through that later. That in itself can be a conflict. So as a practitioner, you have a duty to manage both the actual and potential conflicts of interest, and let's have a look at how you can do that. So when managing your conflicts of interest, you should use your professional judgment to determine the most appropriate method to identify and manage a particular conflict. So a number of mechanisms that you could use to manage these conflicts of interest include disclosing the conflict, controlling the conflict, or avoiding the conflict. And I'll go into more detail about all of those 3 now. Where there is a conflict of interest, you should disclose the conflict to your clients, and disclosure should be made at the earliest possible opportunity. It should occur before or when the service is provided, but in any case at a time that allows your client a reasonable time to assess its effect. It needs to refer to the specific service to which the conflict relates, and it needs to be specific and meaningful to your client so they actually understand it. The form of the disclosure must be sufficient to allow an informed decision to be made about how the conflict may affect the services being provided and about its management. If you intend to accept instructions from more than one party in a transaction, it's highly recommended that before accepting any form of consideration, you are satisfied that each of the parties is aware of your intentions to act for the others and that there is a consent to continue to act. In addition, if one of the parties refuses to provide the requested consent, you should consider declining to act for that party. So now we look at controlling the conflicts of interest, and this requires you to identify the conflicts of interest relating to the services you're providing. It requires you to assess and evaluate the conflicts, and you need to decide upon and implement appropriate responses to those conflicts. So depending on the circumstances, you may also be able to control a conflict of interest by physically or intellectually separating and isolating persons within your practice who will provide the relevant advice from persons who are privy to material information which may influence the advice. And this is sometimes referred to as an ethical wall. In some cases, ethical walls may be an ineffective form of conflict management, noting that there is always a risk of leakage, and there also needs to be an appropriate understanding and written policies and procedures regarding that ethical wall. In some instances, it may be necessary and appropriate to suggest to a client, notwithstanding any advice provided by you, that the client obtain independent advice in the circumstances. However, in all circumstances, it is highly recommended that you keep adequate records, notes of the steps taken to control the conflicts of interest. Finally, avoiding conflicts of interest. As a registered tax and BAS agent, you are required to ensure that your objectivity is not impaired by a conflict of interest. And in some cases, regardless of the arrangements you put in place, conflicts of interest will be unmanageable. And the only way to adequately manage the conflict is to avoid it altogether. And this generally requires you to decline acting for the client. Some other techniques to manage conflict of interest could include placing an onus on employees or anyone else providing relevant services to declare conflicts of interest, including reporting to appropriate people and signing relevant declarations as appropriate in your practice. Developing a register of private interests in conjunction with appropriate protocols, of course, and regularly revising that register. Reviewing conflict of interest declarations periodically. Relevant training, including employees or anyone else who's providing services to ensure appropriate awareness and understanding of what constitutes a conflict of interest and how to act in accordance with relevant internal procedures and protocols. And if you are unsure, seek advice from an independent third party, which, may be a lawyer or, legal advice. So let's have a look at some examples of Code 5 relating to the conflicts of interest to help contextualise what we have already discussed. So here we've got Miranda. Miranda's a tax agent and she receives a commission for recommending clients purchase a licence for a particular software, something that I'm sure most of you on this call are aware of or familiar with. When she recommends software or technology to her clients, Miranda needs to first and foremost ensure the needs of her client is being met and what will make their business most efficient and productive. The issue here is that the conflict is Miranda is receiving a benefit as the result of recommending the software to her clients. Now, there is nothing necessarily wrong with this arrangement if the recommendation is in the best interests of her client. The software may indeed be the best option for the client and she recommends it, but she has a personal interest that could be in conflict with the duty that she owes to her client. So as we've previously talked about, Miranda needs to use her professional judgment to determine how best to deal with the conflict of interest adequately when it arises. So she should first disclose the conflict to her client and, if possible, control that conflict. So, for example, she could recommend a number of software programs to her client with a list of pros and cons of each, including that she will receive a commission. And this allows the client to make an informed decision based on a number of options. Ultimately, Miranda must ensure her objectivity is not impaired by a conflict of interest and that suitable controls are in place. Now, here's one I kind of talked about a little bit earlier, and here we're talking about clients going through a marital breakup, which, 50% divorce rates, it's quite common in our space. So here we've got Terence and Sandra, who are recently divorced. They've always used the same tax agent, Craig, for the past 7 years. In preparing their respective income tax returns, it becomes apparent to Craig that Terence claiming a particular rebate would prevent Sandra from claiming that rebate. Additionally, a perceived conflict may arise in regard to one or both of the clients holding any belief that Craig may not be able to objectively provide appropriate and impartial services to the clients. So in this case, Craig appropriately discloses his conflict of interest to Terence and Sandra, and he receives a waiver from both parties in relation to the conflict. In applying his professional judgment, Craig determines the rebate is more properly claimed by Terence. However, Craig also identifies that he is in a position whereas his duty to Sandra is in conflict with his duty to Terence. So in this case, Craig has satisfied his obligations under Code Item 5 by appropriately disclosing the conflict of interest and obtaining a waiver from Terence and Sandra prior to preparing their respective income tax returns. Alternatively, if Craig were unable to get a waiver from Terence and or Sandra, it's unlikely he'd be able to adequately maintain that conflict of interest regardless of the other arrangements that he could have in place. So he would then have to consider declining to act for one or both of them. And I'll just put another note on that one is just because Craig gets a waiver from them this year, best practice would indicate that he should also get one next year as well, because situations can change quite a lot in a year, as we know. Anyway, Julie, I'll hand over to you to do our final poll of the day.
Thanks, Deborah. Yep, this is our final one for today, and it relates to conflicts of interest. So again, we're just going to ask you to consider the scenario and select the correct response from the list that we'll give you in a second. So in this situation, we have Lucia, who's a registered BAS agent. She's asked by a client to refer an appropriately qualified tax agent to provide advice in relation to superannuation. Lucia is aware of a number of suitable registered tax agents, but refers her client to ABC Accounting because she receives a fee for the referral from this company. Lucia discloses that she will receive a fee for referrals to ABC Accounting to her clients and includes it in the signed letter of engagement. So in this situation, do you think that she has satisfied her obligations under Code Item 5? So again, you've got the three choices there, yes, no, and unsure. So we'll just launch that poll for you now, and we will give you a moment again to select your responses, and then we'll come back and share that with you all. Okay, I'm just going to keep that open for a bit longer, everyone, so you can put through your responses there. Okay, we've still got people responding, so I'll keep it open for a few more seconds. Okay, hopefully everyone who wants to respond has done so, and we'll close that one off and we'll share the responses with you as well. And we've got about 83% saying yes, they have complied, about 11% saying no, and 6.5% or so saying that they're unsure in the situation. So thank you everyone for putting through responses to that poll. And Deborah, I will once again hand back to you. Thank you.
Great, thank you. In this situation, Lucia has a conflict of interest as she receives a financial incentive in referring her client to ABC Accounting as opposed to another registered tax agent. So, but in this case, she has satisfied her obligations under Code Item 5 because Lucia appropriately discloses her conflict to her client in her engagement letter. So, yeah, well done, Lucia. And thank you for everyone for doing that. So if we move on now to consequences for failing to comply with the code, the TASA provides a range of administrative sanctions the TPB can impose if a registered practitioner fails to comply with the code. There's also a number of civil penalty provisions in the TASA relating to certain conducts of registered practitioners and certain activities of those who are acting as unregistered tax practitioners as well. If we find that a tax practitioner has failed to comply with the TASA, including the code, we may impose one or more administrative sanctions or seek a court-imposed civil penalty. Sanctions can include written cautions and orders, and an order is generally requiring a tax practitioner to do certain things like complete a course of education or training that we specify only, or restricting what they can provide or certain services, providing services only under supervision of another registered practitioner. We also have suspension and termination of registration as well. The severity of a sanction depends very much on the nature and extent of the breach and the individual circumstances in each and every case. Practitioners do have the right of review with the Administrative Appeals Tribunal, or the AAT, and the AAT does provide an independent review if required. So I'll just have a quick look at some real-life compliance cases that we've had and talk to you about those. And the first one relates to conflicts of interest. And here we have the TPB terminated the registration of a New South Wales tax agent on the grounds that they were no longer a fit and proper person, given that they had entered into a series of loans with a client without proper written agreements or providing security for those loans. They failed to have adequate arrangements in place to manage the apparent conflict of interest arising from these loan transactions with their client. And they sent messages to a client threatening to withhold loan interest for payments unless the complaint to the TPB was withdrawn. And we really take that type of action even more seriously than I can tell you. The tax agent was the director and sole supervising agent for their company, and the registration had been terminated by the TPB previously for the same conduct. The tax agent attempted to separate their actions from those of the company. However, the AAT considered that the distinction could not be made given that the tax agent was the sole supervising agent and therefore the guiding force behind the company. The TPB's decision to terminate a tax agent's, the TPB then decided to terminate the tax agent's registration and impose a 1-year non-application period, and that was affirmed by the AAT. In another case, this one is about confidentiality, and in this one we had a case where a tax agent company's employee, so someone who worked for the tax agent, was found to have unauthorised access to a former client's tax information without the company's knowledge and in breach of the company's policies and procedures. The employee advised that she was unaware that the client in question had ceased to be a client of the company and thought that she was acting legitimately when she accessed the information and provided it to a third party. Based on the information that was available, the TPB's Board Conduct Committee determined that the company had breached Code Item 6, which is the confidentiality of client information, because it disclosed information relating to a former client's affairs to a third party without their permission or legal duty to do so. The Conduct Committee also noted that the company did not have adequate internal systems in place to protect client information and guarantee the security. However, the company had now revised its policies and procedures to ensure that that kind of situation could not happen again in the future, and the new procedures and policies included staff training sessions to emphasise client confidentiality and the requirement to obtain consent before disclosures, and also system changes to ensure access to a former client's tax information is terminated once the client notifies the company that they no longer wish to use their services. The BCC took into account that the new procedures and policies were in place and the fact that the employee was actually let go by this company. And so the Conduct Committee decided to impose a written caution on the company for its failure to comply with the code. Now, before we finish today, it's been a very heavy session, so thank you for sticking with us. But I'll hand over to Julie. And Julie, if you wanted to go hit me with any of your questions that you've had in the chat over the last hour.
Absolutely, I've got some for you here. So the first question that I have is, do tax practitioners need to seek consent every time they make a disclosure to the same third party? Or would an annual consent, say with the engagement letter, be enough?
Really good question. It depends what that information is, right? And I don't know if many of you on the line know, but I'm a tax practitioner as well, a tax agent, and I'm thinking it depends what sort of information you're talking about. So if you're giving information to the ATO in the form of a BAS or, you know, that kind of thing, there are laws around that because it's an approved form. But STP, there are separate laws on that. Or if you are providing information to, say, a franchisee. So I think it really does depend on the individual circumstance and who it is you're reporting, whether it's on an approved, whether it is an approved form. So all of that kind of information. So I'm really sorry, that question's a little bit broad to give a definitive answer, unless Nadia wants to add anything, unless I've misunderstood the question, which is always possible.
Nadia, did you have anything you'd like to add there at all?
I would just say that generally you wouldn't need another consent every time you make a disclosure if it falls within the realms of the original consent. So if you've received consent from your client that a certain type of information is going to be provided to third party X to help provide services to you, it would only be, I think, generally if the nature of that disclosure changes in some way, then it would be expected you go back to the client and get an updated consent to cover the new disclosure.
Great, thank you. That makes sense. So thank you, Deborah, as well for your response there too.
Oh, I love having Nadia here. She's
always
so smart.
Absolutely, that's why we have her. So, Deborah, I have another question for you, and this one is in relation to employees of a tax practitioner. So can you let us know, are employees of the tax practitioner considered to be third parties for the confidentiality requirement? And then the second part is, should the consent authority also expressly provide for disclosure to employees?
Yes and yes. So third party, when you make the original arrangement is between you and your client. So if it's between me and you, Julie, and if I've got an employee, I need to cover that it covers my employees as well. And Julie, if you wanted me to speak to your partner, you'd need to give me permission for that. So it is really important because otherwise it is just between you and I.
Okay, great. Thanks, Deborah. The next question I have for you is someone's asking, in the webinar you spoke about being able to disclose clients' information to a third party where there's a legal obligation to disclose it. Could you possibly give us some examples of what that would be?
Sure. So situations where you would have a legal duty to disclose could be if, for example, the TPB sends you a Section 6100 notice from the TASA, which requests that you provide the board with specific information, documents, etc. In that notice. It could also be a court or tribunal direction order or other court process that requires you provide that information. It could be AUSTRAC if they have some. They've got power under the Anti-Money Laundering and Counter-Terrorism Financing Act 2006. And it could also be the ATO under a notice, and that's under Section 353-10, Schedule 1 of the Taxation Administrations Act, about taxation laws. So, there are a few instances like that, but it's really important that if you are concerned whether there is a legal duty to disclose, best to get independent legal advice.
Great advice. Thanks, Deborah. The next question I have, when it comes to defining third parties, would a third party also include a family member of the client? So, for example, the spouse, which I think you've sort of touched on already, but if you could just elaborate a little bit.
Yeah, a third party is anyone other than you and your client.
Yeah.
So, if you wanted to speak to, my husband or my wife, you would need to get permission. It's always anybody other than the two of you. And, it's really important that you also look at that in the context of when you're dealing with a business. So you might have permission from, one director in the business, but do you have permission to speak to their employee? And if that employee moves, that you get more consent. So, there's it's a changing thing, but you need to be making sure that you have consent every time.
Excellent, thank you. The next one I've got is around TFN. So this person's asking, should a tax practitioner use the engagement letter to get their client's permission to use their TFNs in email?
Thank you for this tricky one. You do need to seek prior specific consent from your client, preferably in writing, for any proposed disclosure, including the entity that will receive the information and the use of email to disclose that information. And yes, that may include being in a letter of engagement or consent from the client. And this will further minimise any risk of the breach of Code Item 6 in circumstances involving disclosure of a client's TFN information by email without the client's permission. However, note that getting the client's permission does not override the broader privacy and security obligations of a registered tax practitioner under the TFN rule and the Privacy Act 1988. So, and in that it's registered practitioners must still take reasonable steps to protect TFN information sent by email, regardless of whether the client's permission has been obtained. So we did hold a webinar, I think, on that last year, Julie, with, I don't think I did that one. I don't remember it, but I know we did one.
We did. Yeah, right.
Yeah, we did. So, Julie, if you can send a link with that after
Absolutely.
the webinar today, because that's a much bigger, broader issue as well.
Yeah, agreed. I'll send that out, no problems at all. So I've got another question here for you, Deborah, and this one's a registered tax agent asking if they outsource their clients' bookkeeping work to other bookkeepers here in Australia, and they mention this arrangement in the engagement letter. Is there anything else that the tax agent has to do in terms of the Code of Professional Conduct?
No, as long as it's in your engagement letter and it clearly informs your client about the information you're disclosing, it advises your client to whom and where the disclosure will be made, and it gets your client's written permission, you're right. But one more thing I will I will note here is that it's really important to check the TPB register if you are outsourcing, particularly to someone here in Australia, to see whether the person or entity that you're outsourcing to has been sanctioned by the TPB. Current rules are that a practitioner that's been terminated cannot be engaged, employed or contracted for the first 12 months. So, really important that you go to our register and double check that they're not a deregistered agent. And if they are registered, generally you're not responsible for the work of another registered tax practitioner. And that's particularly important when you start thinking about the relationship between a tax and a BAS agent, or even a tax agent and an R&D agent, R&D specialist who's because a tax agent should be able to rely on the work of another registered agent, a BAS agent. So anyway, maybe we can talk about that one in reasonable care one day.
Thanks, Deborah. Some good things to consider, I think, there. I'll just ask you one more question for today. And this one is about identity crime. And we've got the person asking here how we can avoid fraud through identity crime and ensure the true identity of the person we're seeking, that we are speaking to before disclosing any information.
Yeah. Look, it's really important to carefully check your proof of identity documents and to question discrepancies in information that is provided to you. You do have an obligation under Code Item 9 to take reasonable care in ascertaining a client's state of affairs, and that includes their identity. So we strongly recommend you perform identity checks for every new client before accepting them as clients. Existing clients, in particular where personal information has been altered or information relating to the tax affairs is inconsistent with information that you know about them and their affairs, all representatives of clients. So, that's, I guess, if we look at that entity type situation, a director and the people that work for them, and also, you can use these sorts of details to check their identity, their TFN, their full name, their date of birth, their address, their phone number, bank details, employment details, etc. But, with increasing digital world that we live in, there's a heightened risk of dealing with information in an online environment, and particularly with clients that you may not have physically met. Over the last 2 years, I know I've engaged clients that I've never physically met, but I did, like proof of identity over Zoom, having a look at their, driver's license, etc., all of that kind of stuff. And for any online or electronic transaction, you still need to take appropriate steps to be satisfied that the client is actually a genuine taxpayer. The client is who they say they are, and the identity hasn't been stolen, and the information that they're providing to you is correct and can be substantiated. And I know we've only got 1 minute, but we did have a situation with a tax agent in New South Wales where they had a client. They'd been doing this person's returns for a couple of years, and then the person rang in to do it, dealt with a different person in the office, and it turns out that that was actually that person's identity had been stolen. So, really careful to make sure you've got all those checks and balances in place in your practice.
Definitely, that's good advice again, Deborah. And I'll also just mention here too that we have released some new guidance on proof of identity and client verification, which you'll find on the website, and we'll try and send you a link to that as well. But we do have a webinar next month on that topic, so if you are interested in learning a little bit more about that, just jump onto the website again and you can register for that session. We've got that coming up very soon. So Deborah, I'll hand over to you once again just to give some information on how everyone can stay in touch with us, and then we'll wrap it up.
Fantastic. Thank you, Julie. If you'd like any more information or keep up to date with us, our website, tpb.gov.au, is a wealth of information. As I said, the practice notes and all of those things, we are constantly updating and trying to make them more practical, better examples, etc. You can also follow us on LinkedIn, Facebook and Twitter. We have a newsletter that goes out every month called TPB e-News, which you can subscribe to at tpb.gov.au/newsroom. got a YouTube channel where we post all our webinars on there. They're all recorded. Comprehensive library of webinars on anything and everything, and better still, A, they're free, and B, you can claim CPD for watching those videos. I'd like to say thank you to everyone for joining us today. It's lovely to have over 2,000 of you with us today, and a really big thank you to the team at the TPB for supporting me today on this webinar. You guys always do such a fabulous job, so thank you, everybody.
Thanks, Deborah. It was really great having you on board today, and all that information I'm sure everyone's found extremely useful. So thank you for that. And also thank you, Nadia, for answering the questions in the chat box. It was great to have you on board as well. Thank you also once again for joining us today. We do hope that you found the webinar beneficial. Just helps to keep you up to date. And as we've said, it does count towards your CPE. But please do remember that we do not issue attendance certificates. Like I said before, if you're interested in attending more of our webinars, you can jump onto the website. It's tpb.gov.au/webinars. And then one last thing today before we do finish up, I'll be launching an exit survey, and we would appreciate it if you could take the time to complete it. It's very quick, only takes a moment, and it does help us improve on the webinars, and you can let us know if there's anything else that you're interested in hearing about as well. So the survey just opens up in your browser once you leave the webinar. Once again, thanks everyone for joining us, and we do hope to speak to you again soon. Thanks all.